there are several important procedural reforms that the PREVAIL Act is trying to put in place, and I think these have developed over several years. One is to put in a standing requirement, just like you'd be in district court, and even in the trademark opposition system, where the person that's filing a petition has to have a real stake in the patent, whether that be they've been sued for infringement or they're charged with patent infringement. Another important reform is that there'd be one forum to hear a patentability challenge to the patent, whether that's in the Patent Trial and Appeal Board, whether that's in re-exam in the patent office, or district court, or the International Trade Commission, so that the petitioner would choose where this challenge is heard and would give up other challenges. And this would effectively end these so-called fintive factors, which is a discretionary tool that the board may use to deny a PTAB petition in favor of the district court. And I'll mention one other important reform. The legislation would apply estoppel at the time the petition is filed. And so under the current regime, the petition has to be decided by the board finally before estoppel would apply and prevent people from filing separate challenges. But this would change that. And once it's filed, that's it. You're stopped from filing other challenges.
You know, a grand ambition of the PTAB to begin with was to make basically district court decisions and analysis more consistent throughout the country for patent litigations. And, you know, candidly, I don't know if we're any closer to that now than we were before the advent of the PTAB. However, in the PREVAIL Act, there are more efforts to try to bring the PTAB both in line with the district court and to increase that continuity and consistency, including unifying, hopefully, a claim construction standard at the PTAB that won't detract or conflict with anything that happens in the district court. One of the biggest challengers to the PREVAIL Act that we're going to see likely are those that have carved out a cottage industry of sorts for this exact procedure that the PREVAIL Act addresses, which is standing. And so there has been a cottage industry, certainly since the PTAB's advent, that has come out as third-party financiers and other investors to challenge these patents at the PTAB without an actual standing requirement. And so increasing standing to say that it has to be somebody who's been a part of a litigation that involves that patent, and if they have invested, they can invest in serial petitions. It's sort of a one bite at the apple versus multiple bites at the apple. I think you'll have to see a lot of businesses and frankly, petitioners reconfigure their strategies in light of that. So another important pushback that's coming in the PREVAIL Act is the idea that serial petitions, both in terms of the IPR, serial IPR petitions, as well as IPRs with a serial re-exam, are going to have to become more divergent potentially. That is, that the petitioner is going to have to choose which path they want to go down and get their best arguments in line from the beginning, because they may only have one bite at the apple.
And I understand it's a bit of a grab bag of proposals, but I think they're all unified under this common theme of 80% of patents that enter an IPR, their claims are invalidated. And of that set, 65%, all the claims are invalidated. And so, you know, I think the sponsors of this legislation think that it's tilted one way and that these reforms may help roll the pendulum back. And so I think we'd put these reforms in place and see how the landscape changes.
Really, the PREVAIL Act hasn't changed much of the advice that I'm giving any client, which is to be thoughtful and strategic in what they do in terms of their post-grant proceedings. That is, to take these very seriously, you know, get your strategy together, get your best arguments as well as you can, and take the best shots you can right from the beginning. That doesn't change necessarily with the fact that you may not have these backup positions and these abilities to pursue other, you know, challenges like a re-exam after an IPR. But it's the same advice, which is just to measure twice and cut once in terms of your post-grant proceeding strategy.